This video is brought to you by Cleary & Co Solicitors. Today's video is about redundancy in Ireland. What can happen in a Redundancy Ireland claim situation is that an employer makes the employee redundant and the employee has confidence that the lump sum requirement will be paid by the employer around this time. Then consultations between the former employee and employer take place over a period of time with promises of payment being made, until eventually the employee realises they are not going to be paid their statutory lump sum entitlement, and then they consider legal action. Right to Redundancy Ireland, redundancy pay. An employee's right to redundancy pay stems from Section 7 of the Redundancy Payments Act 1967, which states, an employee, if he or she is dismissed by his employer by reason of redundancy or is laid off or kept on short time for the minimum period, shall, subject to this Act, be entitled to the payment of monies which shall be known, are in this Act referred to as redundancy payment, provided A. He has been employed for the requisite period, and B. He was an employed contributor in employment which was insurable for all benefits under the Social Welfare Acts 1952 to 1966. Lump sum payment obligation. If an employee is dismissed and the reason for the dismissal is redundancy, then the employee has a right to a lump sum payment, provided they have 2 years continuous service completed. An employee is entitled to 2 weeks statutory redundancy payment for every year of service plus a bonus week. How to claim redundancy in Ireland. If you've been dismissed and an employer has not discharged by the redundancy lump payment to you, you can apply to your employer for payment by using the following form, an RP 77. If your employer fails to discharge their redundancy payment liability to you, you may seek to bring a complaint to the Workplace Relations Commission. If you feel you've been dismissed unfairly or unfairly selected for redundancy, you might be entitled to bring a claim for unfair dismissal, as employment dismissals have to be conducted in accordance with the law. Dismissal by reason of redundancy has to be a genuine redundancy situation, that is in accordance with a set of number of reasons as set out by the Redundancy Payments Acts. If an employer is unable to pay the redundancy, they can complete an RP50 form, and this can be submitted to the Department of Employment Affairs and Social Protection, who can then discharge the redundancy sum liability of the employer to the employee out of the Social Insurance Fund. Here are some frequently asked questions about redundancy in Ireland. What is the redundancy statutory sum in Ireland? An employee who qualifies is entitled to 2 weeks statutory redundancy payment for every year of service plus a bonus week. Can you make someone redundant and then replace them? This should not happen, and the employer may be open for an unfair dismissal action being taken by the former employee. In redundancy, it is the position, role, job that becomes redundant. If an employer terminates an employee giving a reason for the redundancy, the only valid reasons for the redundancy are those permitted by the Redundancy Payments Acts. How do you prove unfair redundancy? There is a significant difference between a genuine redundancy and a sham redundancy. A sham redundancy can give rise to an unfair dismissal claim. If a disingenuous redundancy reason is given, this is unfair and contrary to the legislation, and it can then be the duty of the employer on which the burden of proof resides to prove no unfair dismissal arose. How is redundancy calculated? To calculate redundancy, you need the date of commencement, the date of termination, and the gross weekly sum. By typing in the above information to a redundancy calculator, you can find many online. It will give you the sum you are entitled to. What is a true redundancy situation? There are 5 reasons set by law whereby dismissal constitutes a redundancy. These are A. The fact that his employer has ceased or intends to cease to carry on the business for the purposes of which the employee was employed by him, or has ceased or intends to cease to carry on in that business in the place where the employer was so employed, or B. The fact that the requirement of that business for employees to carry out work of a particular kind in the place where he was so employed have ceased or diminished or are expecting to cease or diminish, or C. The fact that his employer has decided to carry on the business with fewer or no employees, whether by requiring the work for which the employee had been employed to be done by other employees or otherwise, or D. The fact that his employer has decided that the work for which the employee had been employed should henceforward be done in a different manner for which the employee is not sufficiently qualified or trained, or E. The fact that his employer has decided that the work for which the employee had been employed should henceforward be done by a person who is also capable of doing other work for which the employee is not sufficiently qualified or trained. Many of the above genuine reasons for redundancy relate to the economic need of the enterprise. Redundancy dismissals are not about the employee's personality, performance, or personality clash with the employer, for example. Genuine redundancy situations are impersonal to that employee. Disclaimer: please be advised that the mentioned material is intended as an overview and as a broad outline of the topic discussed. It should not be considered as complete and comprehensive legal advice, nor act as an appropriate substitute. Legal advice should be sought from a solicitor prior to relying on anything in this video. Due care has been taken in the publication of this video, and we do not accept legal liability as a result of reliance on any material covered in the video.